In 1952, Mr. Gillett, a 12-year-old schoolboy, met Mr. Holt, a 38-year-old farmer, at the golf club, when Mr. Gillett was earning pocket money as a golf caddy. Later, Gillett became Holt's regular caddy and good friends. As time went by, Gillett became a regular visitor to Holt's house, the Limes. While helping on the farm, Gillett sometimes also stayed at Holt's house. In 1955, when Gillett was 15 years old, Holt proposed Gillett to leave school and work full-time for him. Despite objections from Gillett's headmaster and parents, Gillett accepted Holt's proposal. Throughout the years, Holt paid £15 a week to Gillett and later increased to £17 a week after Gillett's marriage. Holt expanded his farming business by employing a few more staffs. Gillett's responsibility became more important in Holt's farming business. Around the years 1958 to 59, Holt approached Merton College, Oxford, the landlord of the Limes, to inquire whether his tenancy in the Limes could be put in the joint names of himself and Gillett. In the alternative, Holt suggested to Gillett and his parents about adopting Gillett in order to give a right of succession to his agricultural tenancy. This proposal did not materialize. In 1961, Gillett met Sally Wingate. The Gilletts got married in December 1964. Mrs. Gillett gave birth to 2 sons, Robert and Andrew. The Gilletts family became Holt's surrogate family. In summer 1964, Holt told Gillett to be in charge of the farm in due course, and indicated his intention to leave his farm to Gillett. Since Gillett got the harvest successfully, Holt retired from day-to-day involvement in the farm work. In 1971, the Gilletts went to live in the Beeches at a rent of £70 a week. Since the Beeches was in poor condition, the Gilletts carried out repairs and improvement there. In 1971, Mr. Holt attended Gillett's son's christening as his godfather and gave a speech. The birth of Robert will enable my farming business to continue to the next generation. In 1973, Holt repeated once again that Gillett would bequeath all his assets, at least the entirety of his farming business, free of tax liability. In 1974, Holt appointed Gillett as executor of his will and showed Gillett some papers, which gave the impression that he would ensure Gillett to bequeath his entire estate. In 1975, Gillett requested a written document to confirm that the Beeches farm would be his and his family, but Holt refused. Gillett discussed with his wife and parents about this matter, and decided that Mr. Holt was a man of his word, and so he accepted Mr. Holt's assurances. Happy birthday to you. In 1984, the Gilletts organized a party to celebrate Holt's 70th birthday. Holt was pleased and said that the Gilletts family had a very secure future. In 1989, Holt went to hospital for prostate operation. Holt told the Gilletts that if anything went wrong with the operation, his assets will be theirs, and directed them to look after other farm staff. In 1992, the relationship between Holt and Gillett turned bad due to the appearance of David Wood. The relationship between Holt and Wood was observed by Holt's family and friends as something of obsession. In February 1994, Wood replaced Gillett as the principal beneficiary under Holt's will. By 20th of November 1995, Gillett lost all the beneficial interest in Holt's will. On 27th November 1995, the Gillettes were summarily dismissed from Holt's company.
Fight! Perfect.
First of all, to establish a case on proprietary estoppel, three elements have to be present. The first is an assurance that the promisee will acquire a right over a property. The second is a subsequent reliance on the strength of that assurance. And lastly, the promisee act to his detriment in reliance of that assurance.
I agree with my learned friend. But then, although proprietary estoppel is divided into three separate elements, it is important to note that the doctrine of proprietary estoppel cannot be treated as subdivided into 3 or 4 watertight compartments. The quality of the relevant assurances may influence the issue of reliance, and reliance and detriment are often intertwined. Moreover, the fundamental principle that equity is concerned to prevent unconscionable conduct permeates all the elements of the doctrine. Fight! Perfect.
It is not in dispute that for a long period, Mr. Holt intended to leave the bulk of his estate to the Gilletts. In fact, a will was executed to that effect. However, what I am unable to find in the representation made by Mr. Holt is anything which could reasonably be construed as an irrevocable promise, regardless of any change in circumstances. Mr. Gillett must have been well aware that his expectations were dependent on Mr. Holt's continuing goodwill, which could be withdrawn at any time, and the representation that Mr. Holt had made were not legally binding in any way. On this basis, I am not satisfied that the element of assurance was made out on these facts.
My learned friend, this is incorrect. In establishing assurance for proprietary estoppel, it is simply incorrect to look for an irrevocable promise or an assurance that the promisor will not revoke his promise. The irrevocability of the promise comes from the detrimental reliance by the promisee. The inherent revocability of testamentary dispositions is irrelevant to the question of whether there was an assurance, even when the promise or assurance is linked to the making of a will. The circumstances may make clear that the assurance is more than a mere statement of present intention. And in the current case, the assurances were repeated over a long period of time, and the circumstances in which those 7 assurances were made were mostly in special family occasions. Hence, there is a clear intention that those assurances were meant to be relied on. Fight!
The in rebellion principle requires some mutual understanding as to the quid pro quo for the promise. Gillett had been allowed to enjoy his stay in the property in return for services than in relation to a whole estate.
My learned friend, you are wrong again. You have taken too restricted a view of the element of this very flexible doctrine. Can't you see that in Holt's speech on the occasion of his 70th birthday party in 1984? Holt promised to reward Gillett for his past, present, and future loyalty and hard work, which made Holt's life more pleasant and prosperous. I believe that is such mutual understanding.
Fight!
Apart from being underpaid for a significant period of time, Mr. Gillett claimed to have suffered various other detriments as a result of his reliance on Mr. Holt's assurance, including his refusal of inquiries from other employers, the limited provision made for his pension, the domestic tasks undertaken by him and Sally for Mr. Holt, and the money spent by him on improving the beaches. However, on the contrary, Mr. Gillett also enjoyed the benefit of working for a generous employer who on various occasions provided him with gifts for the family and provided for the school fee for one of his kids. Mr. Gillett decided at an early stage of his life that his future lay with Mr. Holt, and as with most human relationships, that involve obligation and compensation. I cannot find on the balance of advantage and disadvantage that Mr. Gillett suffered a detriment.
My learned friend, I respectfully disagree with you. My learned friend, this is unconscionable. You focused on the balance of financial advantage and disadvantage. I don't think it is correct to take such a narrow financial view of the requirement for detriment. Detriment need not consist of the expenditure of money or other quantifiable financial detriment, so long as it is something substantial. The requirement must be approached as part of a broad inquiry as to whether repudiation of an assurance is or is not unconscionable in all the circumstances. In the current case, Mr. Gillett and his wife devoted the best year of their lives to working for Mr. Holt and his company, showing loyalty and devotion to his business interests, his social life, and his personal wishes. On the strength of clear and repeated assurances of testamentary benefits, I would call that a substantial detriment and would be unconscionable if Mr. Holt is allowed to go back on his promise.